Hello, everyone, and welcome to today's webinar on rules of advocacy and lobbying for grantmakers. I will hand it over to today's presenters, Council on Foundation Staff Counsel, Rami Barnwell and Ben McDearman.
Thanks, Daniela. So we're going to get started right away. Our first discussion is just going to be about lobbying and an overview of what lobbying is. And so when we discuss lobbying today, generally we mean influencing or attempting to influence legislation. And that definition comes from Treasury Regulation 56.4911-2B. And if we could just go to the next slide. So a quick disclaimer, this presentation is not meant to provide legal, tax, or financial advice. So we do recommend that you seek the advice of your own legal, tax, or financial professional if you have specific questions. Any communication that we give after this presentation isn't meant to be used for the purpose of avoiding any tax-related penalties. So an agenda for today, first we're going to have an introduction to lobbying, just sort of go over definitions, and then we'll have a discussion of lobbying limits for public charities. After that, we're going to discuss the options for private foundations when it comes to engaging in political activity. And finally, we'll discuss engaging in policy without lobbying, so that big, broad universe of things that your foundation can do without concern. So this is just the first section, that introduction to lobbying. And as I mentioned, when we talk about lobbying, what we generally mean is attempting to influence or influencing legislation. And 501c3 of the Internal Revenue Code states that to qualify as a charitable organization, no substantial part of the organization's activities can consist of carrying on propaganda or otherwise attempting to influence legislation. So that last part, influencing legislation, is where we are in today's discussion. When it comes to political activity, 501c3 also states that organizations, exempt organizations, can't participate in or intervene in any political campaign on behalf of or in opposition to any candidate for public office. So that's also going to fall under that bucket of lobbying. So a basic overview of what we're going to go through. Generally, private foundations are prohibited from engaging in lobbying, although we will discuss some exceptions to that rule that will give you guidance for what your private foundation can engage in. Public charities are permitted to engage in an insubstantial amount of lobbying, and we will discuss later in today's webinar how to determine what that insubstantial amount is. But generally, other types of non-lobbying advocacy, your foundation is unlimited in what it can do, and we will have specific examples of that behavior at the end of today's presentation. When we discuss lobbying, we're talking about one of two types of lobbying. There's direct lobbying and grassroots lobbying. And really the biggest difference between those two is who the audience is, whether it's legislators or the public. But for both of those types of lobbying, direct and grassroots, then time by staff will have to be reported on timesheets and then eventually on your Form 990. And it's important to consider that if you do spend a substantial part of your activity, so if you cross that insubstantial threshold to influence legislation, then you won't be considered to operate for exclusively exempt purposes. So what is lobbying? I discussed those two different types of lobbying, the first being direct, and it's important to think of these definitions more like tests. You need all of the characteristics to meet the definition. So for direct lobbying, it has to be a communication with a legislator, expressing a view about specific legislation, and we will break down the different parts of this test. For grassroots, it also has to be a communication with the general public, expressing a view about specific legislation, and it must include a call to action. Sometimes it's easy to get lost in what is considered a communication. So I think it's really important to note that it doesn't need to be a formal letter on foundation letterhead sent directly to the named legislator. It can be something as informal as a social media post directed at that legislator, or even something as obscure as a carrier pigeon sent to the staff secretary of that legislator, seeking them to do something with a specific piece of legislation. So legislators defined, it's going to include federal, state, and local representatives. It's also going to include executive officials. So anybody in the office of the legislators is included. And then if it's a ballot measure, so if there is something that the public will vote on to determine the outcome of a piece of legislation, then the general public is going to be considered a legislative body in the locality where that ballot measure will take place. It's important to note, though, that it doesn't include members of special purpose boards. So school boards, zoning commissions, planning commissions are excluded. Legislation defined. So that's going to include bills that are proposed, drafted, introduced, or under discussion. It doesn't have to have a specific number attached to it, but it excludes regulations, litigation, and executive orders. And I think that it's important to highlight that there is a line that you can cross even when it comes to litigation. So if you were to reach out to your legislator about the EPA versus West Virginia and discuss your disdain with that Supreme Court decision, that would be fine. But if you were to reach out to your legislator and express your disdain with that decision, and then ask your legislator to codify the Environmental Protection Agency's power to regulate carbon emissions, then that's seeking some specific legislation, and that would cross over to that lobbying line. So when we discussed grassroots lobbying, one of those requirements was a call to action. So if you remember, it is a communication to the public about a specific piece of legislation that includes a call to action. So that call to action is going to include anything like urging recipients to contact their legislators, providing addresses or telephone numbers to contact legislators, and providing a mechanism to communicate with legislators, in addition to just identifying those legislators by name, and then trying to direct the public to act in some way. And just before we move on to that next slide, I just want to review that there are two types of lobbying to remember. Considering them tests is the best way to go about it. Direct lobbying requires a communication to a legislator about a specific piece of information. And then that grassroots lobbying is going to require communication to the public about a specific piece of legislation. And there has to be a call to action included.
All right, thank you, Rami. Moving into our next section, we're going to look at what are those lobbying limits for public charities. As we already discussed, it's possible for public charities to engage in limited amounts of lobbying activity, so long as it doesn't constitute a substantial part of their overall activities. So if we move to the next slide, we'll see a chart that helps explain the two possible paths that you can go when tracking lobbying at a public charity. So note at the bottom here, this does not apply to private foundations. We're only talking about public charities for the moment. The first column on the left, the no substantial part, or sometimes called the insubstantial part test, this is the default provision. So it's important to note that you don't have to do anything. You don't have to take any special steps to be treated under this test. This is going to be your default provision unless you elect to be reported under the 501H expenditure test. So under the no substantial part test, the downside to this really is that there is no direct guidance specifically saying exactly what constitutes an insubstantial part of an organization's overall activities. The general guidance, being conservative on this, tends to be keeping it within 3 to 5% of an organization's overall activities. That would not cross the threshold into being a substantial part of the overall activities. What counts against that limit? This is another area where the default provision is a little bit more, or rather a little less favorable to the organization, given that any activity at all, whether that is volunteer time from volunteer members or your board or committee members, including, of course, also expenditures you make, costs of equipment that you use in the office as part of engaging this activity. We're really tracking everything that goes into lobbying activity needs to be accounted for and reported as lobbying activity on the 990. And the consequence here, again, there's less clear guidance exactly where that line is, but conceivably, if an organization were found to have engaged in a substantial amount of lobbying, there is the risk and egregious examples of a loss of tax-exempt status, because that organization could be found to no longer be operating exclusively in furtherance of one or more exempt purposes. On the other hand, the 501H election, which, as you can see on this slide, note that it really only takes one single act, completing IRS Form 5768, to take that election. That remains in effect indefinitely until the organization chooses to revoke that election. But this provides more clear guidance to an organization on the limits in terms of their expenditures. And of course, it's important to note here, in this case, under this test, we're now only talking about actual expenditures by the organization. So it's a little more straightforward in that sense as well, given that there's a smaller universe of things that you've got to track for. We'll look in just a moment to see some more detail on the specific limits that are set. But there's a sliding scale based upon the budget of an organization that tell you how much you can spend in a given year without incurring a penalty tax. And so again, of course, the distinction here is there is a specific penalty other than simply loss of exempt status in egregious cases for organizations that exceed the limits. Because there are more clear limits, we know when we cross them, there's a penalty tax in place. That tax is 25% of excess lobbying expenditures. So any amount above that non-taxable amount for the year, there's a 25% tax imposed. One note to point out here is that no more than 25% under the 501H election for expenditures can be used for grassroots lobbying for that year. And that penalty tax is actually imposed upon the greater of the amount of either the total expenditures in excess of the non-taxable amount for the year, or the excess over that 25% limitation on grassroots lobbying. So whichever of those is higher would result in that the penalty tax would be imposed against that one. So if we move to the next slide, we're going to see there's this chart, which helps you understand what these limits are, but you really can see it's an incremental increase as the budget of an organization's exempt purpose expenditures, which we're really saying is, generally speaking, most things that you're carrying out other than some fundraising costs or maybe some capital expenses. But broadly speaking, the majority of your activities are those that are in furtherance of your exempt purpose. And so those expenditures are the budget that we're looking at. So at a baseline, smallest organizations who are subject and elect to be treated under the 501H election would be able to spend up to 20% of their exempt purpose expenditures on lobbying before they incur that penalty tax. Above that threshold, you see it increases on a smaller percentage of each incremental amount above the threshold for the previous level. So maxing out at $1 million at the top end. Since we've reviewed now ways that public charities can engage in actually carrying out lobbying activity, we're going to transition now to talking about ways that private foundations can fund organizations that engage in lobbying. So we're not talking about activities directly carried out by private foundations. There are some exceptions to the definition of lobbying and the prohibition on private foundations engaging in lobbying that we'll talk about in the next section. But in this case, we are talking about ways that private foundations can fund organizations that do engage in lobbying without themselves incurring a taxable expenditure and being subject to a 20% tax on that taxable expenditure. So first, it's important to state no grants can be earmarked for lobbying. When we talk about earmarking, we mean some agreement, whether oral or written, that a grant is going to be used specifically for lobbying purposes. So that's the first thing to keep in mind. You cannot earmark a grant for lobbying purposes from a private foundation. What that would result in essentially is the organization will have been deemed to have made that grant to an organization on the condition that it use it for lobbying, and we're going to impute that as lobbying by the organization or directly funded by the organization. There are ways, however, that an organization, a private foundation, can fund organizations that engage in some lobbying activity, even if you know that there's going to be lobbying activity involved, and avoid incurring a penalty tax by having made a taxable expenditure. The first of these is to provide a general support grant that's not earmarked for any particular purpose. So very straightforward approach here. You're just funding a 501c3. You can rely on that organization's charitable status to presume that its use of the funds will be charitable. We're talking here presumably about a public charity, which, as we just discussed, can engage in insubstantial amounts of lobbying. So if your grant to a public charity that's not earmarked for any particular purpose ultimately is used in part by that organization to cover some of its lobbying related expenses to the extent that it's allowed to engage in lobbying activity, you will not be found to have made a taxable expenditure in that case. The second way to go about doing this is to make a specific project grant. So one that is limited to a specific project as long as certain conditions are met. The first, again, is that no portion can be earmarked for lobbying. And also, the private foundation's grant can only fund up to the total of the non-lobbying portion of the project budget. So if you're looking at the total budget for that specific project, you have the amount that you understand is to be used for lobbying, and then there's everything else. So a private foundation can fund the total of that grant that doesn't include the lobbying amount, but any amount above that, it's inferred that you're funding greater than the non-lobbying portion. It's inevitable some part of your grant must be used for that project's lobbying purposes and lobbying activities. So some tips on making specific project grants. The private foundation can't be the sole funder of a project that includes lobbying. I think that should be pretty clear, logically speaking. If you can't fund above the non-lobbying portion of that grant, then of that project, then it should be clear that funding the entire project would inevitably include funding some of that lobbying activity. You don't need to know the identity of other project funders. That's a question that comes up, if an organization is aware that, or they have a suspicion that maybe another private foundation is also a significant funder to this project, and they're wondering, well, how do we account for the fact that we're funding a significant part of the non-lobbying budget? This other organization is also funding the non-lobbying budget. We're both private foundations. You don't need to look into whether or not they have non-private foundations who are also funding the project. You're concerned with respect to your own grant to that organization, ensuring that it doesn't exceed the limits of the non-lobbying portion of the project. Assuming that's the case, you don't need to get into the questions of who are the other funders funding that specific project. And so it's important to note too the reason that you can rely on this is that you're funding up to that non-lobbying portion. Then if those conditions are met, even if the organization ultimately uses a part of your grant for lobbying activity, it's not going to be imputed to you. It will not result in a penalty under 4945. So that's why it's important, I think, to, of course, you want to understand the rules here, but knowing what those rules represent, if you follow those, if you satisfy that test, there is some safety built into that with respect to, even if that grant does result in part of your grant funds being used for lobbying activity, it's not going to be imputed to you. And I think finally on this slide, just know that lobbying expenses described in the budget should be reasonable in comparison to what's actually being proposed. So if you looked at a budget and it included lobbying expenses and it seems unrealistically low, given the type of activity that's going to be carried out, that should be a red flag too. You can't get around this, or you can't use that as a mechanism to allow a private foundation to fund a greater portion of a project budget than they would otherwise be allowed to by underrepresenting the extent of the expenses that project will incur lobbying. It needs to be proportional to the actual proposed activities.
So we've discussed just some of the rules around lobbying, but we do want to discuss sort of engaging in policy, the options that you have to engage in policy without lobbying. And if you'll go to the next slide, when we discuss engaging in policy without lobbying, we just want to be clear that those activities don't need to be reported as lobbying hours. It's also important to note that this section includes specific exceptions to the lobbying rules that are outlined by the Internal Revenue Code or the Treasury regulations, and to remember just the definitions for lobbying, to know sort of what qualifies as lobbying, what doesn't, and then what the exceptions are. So one of the first options for your foundation to take is to educate the legislators specifically about foundations and about the work that foundations do, informing how legislators can improve their communities through supporting foundations, or even supporting through grant making the work of another organization in doing that educational work. Another option is educating legislators about specific issues. So you can discuss broad social, economic, and other issues, as long as you're not expressing a view on specific legislative proposals. So if we go back to that example about contacting your legislator about the West Virginia v. EPA case, maybe you want to educate legislators about carbon emissions, but you can't specifically reference the codification of the EPA being able to regulate those emissions, or suggesting some legislation that doesn't exist yet. It's also okay to educate the public on specific issues, social, economic, and other categories. And it's okay to mention legislation, but you can't include a call to action. So just going back to those definitions of lobbying that we discussed before, it's important that you don't meet all 3 prongs for the direct lobbying or all 4 prongs for the grassroots lobbying.
One of the more common ways that private foundations, so again, in this slide, we're talking specifically about private foundations, that is an exception to, as Rami mentioned, some of these are exceptions to that general prohibition on lobbying. So self-defense communications, those where there's a viewpoint that's being expressed in a communication to legislators about issues that affect a foundation's existence or tax-exempt status, or its powers and duties, or deductibility of contributions made to that, those do not technically qualify as prohibited lobbying, even though the elements are there that, otherwise, if not for the specific subject matter here, the activity itself would likely satisfy the definition of lobbying. So 4945E, that section of the tax code, provides that it's not a taxable expenditure for a private foundation to communicate through various forms, as we discussed in the first section, with an entire legislative body or its committees or subcommittees, or even individual legislators, members of their staffs, the executive branch members who are engaged in the legislative process, specifically to oppose or support specific legislation. That's allowed in these cases where the nature of the legislation gets to the heart of these organizations' existence or status or powers and duties, or generally speaking, deductibility of contributions to charities. And so it also allows foundations to spend money to support or oppose specific legislation, and those expenses aren't considered taxable expenditures. So you can directly engage in these activities, in these communications, or you can fund activity that carries out those same purposes. There are some useful examples in the Treasury regulations that help us understand what does it mean to be something that affects a foundation's existence or tax status or powers and duties or deductibility of contributions to it. So some of these examples, a proposed bill that would require private foundations to make certain amendments to their governing documents, or legislation that would result in a loss of tax-exempt status for a private foundation that engages in certain transactions with related parties. So those are two of the examples given. There's also a note in the Treasury regulations that an appropriations bill, even if it directly affects the funding of a foundation, is generally not considered legislation that would impact the existence, powers, duties, tax-exempt status, or deductibility of charitable contributions. Of course, there are a lot of other scenarios that aren't covered by these examples provided. It's worth noting that recently, in the last several years, the council has informed members that, in our view, certain tax legislation that has some impact potentially on charitable deduction. Generally speaking, that should be covered. Deductibility of contributions, certainly. These examples, as noted here, these are all things that foundations can proactively take steps to communicate with or fund communications or activities against or in favor of specific issues in legislation that's being proposed. You don't have to wait, as with some of these other exceptions that we'll note in a moment, for legislators or legislative bodies to contact you specifically. You can actually proactively use this line of self-defense communications. And it's also worth noting here, we're not talking about grassroots lobbying. This can't be in the form of a larger push to the general public, asking them to take some sort of action. We're talking specifically about, in this more narrow exception to the lobbying rules, communications with legislators or individuals or committees that are involved in the legislative process. So another way that you can interact with policy more broadly without it qualifying as lobbying is working with regulatory bodies, so agencies of the federal or state governments, communications with those bodies, people who work on their behalf, for example, working with the IRS, Health and Human Services. Those are permitted. Generally speaking, it's not considered to be lobbying because the term legislative body, for the purposes of that definition of lobbying, doesn't include the executive branch, judicial branch, administrative bodies. These can include, activities like this can include helping influence agency rulemaking, developing relationships with policymakers, or even helping your grantees to do so. These are all acceptable because we are not in the world of making laws by affecting or influencing legislation. There's a narrow exception here, though, where if there's a government employee who's at one of these agencies, normally that person would not be considered a legislator. But if you recall from our discussion of who is a legislator a few sections earlier, one of these people could be considered to be a legislator if they are actually participating in the formulation of legislation, and the intent of your communication with them is to influence legislation. So it's worth being careful around this type of communication with people who are with regulatory agencies to ensure that we really are not falling under this narrow definition where these people could be considered legislators and there is not some attempt to actually influence legislation that's being furthered by that communication. Participating in litigation is another area that foundations, but this is again both public charities and private foundations we're talking about, can get engaged in. That could involve filing a lawsuit on your own behalf as a party. It could mean submitting an amicus brief where you are not a party to the action, but you want to highlight a specific issue or concern or point of law that you want to bring to the court's attention in favor of one side or the other. You could involve serving as an expert witness, assuming that somebody at the foundation is qualified to do so in their capacity as somebody working at that foundation because of the nature of the testimony that you're being asked to give. This could even involve specific laws. I think that's worth pointing out too. For example, signing on to an amicus brief or filing a lawsuit to challenge or enforce a particular law. Or you could fund, for example, litigation that challenges a specific law's constitutionality. So these are examples of things that even though there is a specific law involved, you're not directly attempting to influence the legislators in their formulation of that law. You are funding or participating in directly or indirectly the process of resolving some of these issues around constitutionality or enforcement of a law through the court system. And just a note at the bottom here that this activity carried out and furthered by this lawsuit must further the charitable mission of the organization. It needs to have some connection to the exempt purposes of that organization. We're not just engaging in litigation that is unrelated to your overall mission. It needs to be connected and further some exempt purpose for which you're organized and operated. So providing technical assistance is another area where it's an exception again to the general definition of lobbying, where there is going to be a communication to a legislative body. And frequently it is going to relate in some way to pending proposed legislation, something that's under consideration. So generally speaking, a request for technical assistance is allowed with some caveats. The request has to be written from a committee or legislative body and can't come from a single legislator. So it has to come from one of those groups. It can't be from a single individual on their own behalf. And the response has to be made available to all the members of that requesting body. And a note, the opinions here are okay. So you could actually advocate a specific viewpoint if that request specifically asks for opinions or recommendations, or if it's directly related to the assistance that's being provided. And so I think it's helpful in this instance to look at some of the examples given by the Treasury regulations, because that can be a little bit difficult to parse out. The Treasury regs give 3 examples I think are helpful because it helps flesh this out a little bit. They start off with, let's say there's a congressional committee that's studying the feasibility of legislation to provide funds for scholarships to American students attending schools abroad. And they ask a private foundation that engages in private scholarships of that type. They ask them in writing, the request comes from the committee, so we know we're okay there, to describe how that organization actually goes about selecting candidates for it. So essentially they're describing their selection process. That foundation then responds to the committee's request in writing to the entire committee or subcommittee, and they describe how it goes about making those selections. That's going to constitute technical advice or assistance in helping that committee make a determination whether to move forward with specific legislation. The second example they give, the same facts, except in this case, the foundation then takes it a step further and starts giving some opinions on the wisdom of adopting such a program. Essentially, they're advocating beyond just, they're not describing simply, here's what we do. They take it a step further and say, we believe it's wise decision for you to enact legislation on this because X, Y, Z. The example given actually says that since such views are directly related to the subject matter of the request for technical advice, then that's not going to result in them having incurred taxable expenditure, having engaging in lobbying activity because of the fact that it's related to that specific question that was asked, even though they're advocating for some viewpoint that goes beyond beyond the simple technical question they were asked about. In the third example, the committee actually asks them to, in addition to describing their own procedures, give any views they consider relevant. And so in their response to that, they give opinions that are relevant to the committee, but they are not necessarily directly related to their own scholarship program. For example, they have a discussion of alternative scholarship programs, the merits of which these would all qualify as technical assistance as well. So those are three examples of ways, depending on how the request is phrased, or depending on the nature of these opinions that are being espoused by the foundation providing the technical advice, you can actually get around this general prohibition on direct communications with a legislative body that speak to specific legislation, even if it does advocate a specific viewpoint, assuming that either they're requesting that you give your opinions on it or give any views you consider relevant, or that the opinion that you choose to give, even though they didn't ask for it, is actually directly related to the assistance that you're providing them. It helps them more clearly understand the nature of the work you do. The nonpartisan analysis or research, you can think of this as a study or report or potentially white papers, panel discussions. These can take a lot of different forms. Really what we're concerned about here is that there's a fair discussion, a full and fair discussion of all the facts involved. Ultimately, these reports can actually advocate a position on one side or the other of an issue, and it may discuss direct legislative issues, but they can't directly call the recipient to any action. It can advocate a specific viewpoint as long as there's enough information of the pertinent facts to let the public or an individual who's reading this to form their own independent opinion or conclusion. So you can't just present an unsubstantiated opinion supported by no facts or analysis within the report on a specific issue relative to specific proposed or pending legislation. So that would not qualify as nonpartisan analysis, study, or research. You really need to present enough information for the person reading it and receiving this to make a decision that they can base on all of those facts. So if somebody were looking at this and saying, I can't really follow how you got to this answer or to this opinion that you're stating, you likely didn't include enough. There are actually some examples in the Treasury regulations here that I think are helpful. They give two examples where there's a research project that involves the dangers of the use of pesticides in raising crops, and there's some legislative proposal to rein in the use of those pesticides. The key distinguishing feature in these two examples, the first one, the body that the organization that gives this performs this research doesn't really get into questions of why they end up forming the opinion they do. They simply come to a conclusion without full analysis of the facts involved. And in the second one, they consider the advantages, disadvantages of continued use of pesticides. They consider the advantages and disadvantages of controlling its use. They consider potential alternatives to pesticide use. So they give somebody reading this the full picture, allowing them to essentially come to their own conclusions. So in that example, even though the organization does say we encourage legislative action to curb the use of pesticides in raising crops, that will not be deemed to be lobbying activity. That's actually acceptable under this nonpartisan analysis or research, because they gave all the facts involved, and anyone reading this should be able to draw their own conclusions, whether or not it's the same conclusion reached by the foundation that actually put this project together. This can be distributed to the public or a subset of the public in any appropriate manner. So it doesn't have to take a particular form. It could be either free or with some sort of charge involved, but it needs to be shared with both sides. You can't direct this at just one side or one viewpoint on the issue. It needs to be presented in a nonpartisan fashion. A note here at the bottom that nonpartisan and bipartisan are not the same thing. So we're not talking about research and analysis that looks at specific viewpoints held by both major political parties. For example, you can't do both and say that evens out to being nonpartisan. It truly has to not take a partisan viewpoint, even though you may end up coming to a conclusion that actually does result in you advocating for a specific position on an issue. And the last category we're going to talk about is civic participation, which again, must be nonpartisan. So we always want to highlight that. Because recall, we were talking about at the very beginning, there's generally speaking a prohibition on 501c3 organizations engaging in any electioneering, advocating for candidates for office. And so this is an area to approach with some caution, though certainly there are things that you can clearly do in this area that further charitable purposes and don't constitute electioneering or influencing elections. So first, we'll talk about public charities. Public charities can fund and promote nonpartisan get out the vote campaigns or voter registration drives, either directly or in partnership with some other organization. They can fund it, they can carry it out themselves. They can promote these. The idea is this is encouraging people to get involved in the process, the election process, the political process, really supporting the fundamental tenets of democracy in action. So you can encourage people to get involved. You can educate people about candidates as long as you're not advocating for specific candidates or against specific candidates for office. You can, as I mentioned, fund these activities directly or carry it out in connection with others. Private foundations, now that we're switching gears from what public charities generally speaking can engage in, private foundations are more limited, but they can still support some types of voter registration, voter related activities carried out by public charities. And they can even earmark grants specifically for voter registration drives if they follow some specific rules. So that's found under section 4945F of the tax code. And the requirements, and a couple of them are summarized here, but I'll go into a little bit more detail. So these are, again, for earmarked contributions from private foundations that are to organizations carrying out voter registration drives. The organization, so we're going to look at what is the grantee in question. Does it meet these criteria? It has to be a 501c3. It has to carry out nonpartisan voter registration activities in at least 5 states. And it must occur over more than one election cycle. So that's really important there. We want to make sure these aren't narrowly targeted to just a couple states and in just one election cycle where it looks like we're funding voter registration aimed at a specific election. So a more broad election or voter registration activity carried out by these organizations. The contribution can't require that the grantee uses it in a specific state or in a specific election cycle. So it's important if you are earmarking grants for voter registration drives, you can't say it has to be used, this year in this state, for example. At least 85% of that organization that you're funding, the grantees, income has to be directly spent on activities related to its exempt purposes, and at least 85% of its support, other than its gross investment income, has to come from either exempt organizations, the general public, or government units. So not significant private individuals or organizations funding these outside of that. No more than 25% of it can come from any single exempt organization, and no more than 50% of its support can come from gross investment income. So there are some pretty technical issues to look at and to be aware of when you're talking about funding voter registration drives through a private foundation. But it certainly is possible to do. You just have to exercise some caution when making these grants if you're going to, again, earmark them specifically for those voter registration purposes. Again, you can, of course, make a general support grant to a public charity. In those cases, the rules I just talked about under 4945F won't apply. In that case, the charity could choose to use some or all of the grant for voter registration work without any penalty to the charity or to the private foundation. So another example where general support grants to public charities from a private foundation can be your friend if you want to make sure you're able to fund organizations that carry out some work that otherwise are going to require some more strict hoops to jump through, such as similar to the example of funding under the specific project grant versus funding a just general support grant to an organization that might be engaged in lobbying. So kind of to sum up this section, I think we touched on what the risks are, but it's worth reiterating that those both private foundations or public charities that participate in or intervene in any political campaign or behalf of or in opposition to any candidate for public office could face some serious consequences. Section 4955 of the tax code says that the IRS has the power to impose some pretty strict excise taxes on that organization, starting out at 10% of the campaign expense, whatever is determined to be the expense spent on campaign intervention or electioneering, potentially an additional 2.5% tax on any managers who knowingly violated the law. And then if corrective action isn't taken, which is essentially attempting to recover all or part of the expenditure, putting in safeguards to prevent this from happening in the future. If that's not taken in a timely manner, that tax increases to 100% of the campaign expense that's implemented on the organization and assessed 50% of the expense assessed on the manager. So pretty steep penalties, financially speaking, for organizations that run afoul of this. And as we talked about at the beginning, any organization that's found to be violating these rules and substantially and egregiously violating the prohibition on election-related activity, the ultimate penalty is possibly loss of exempt status. So it's important to be careful in this area in particular, but we want you to view these, the entirety of this presentation as we wrap up is these are rules that you need to understand if you're going to be engaging in work related to policy, if there's work that will be verging on lobbying or advocacy, voter registration. It's important to understand the rules and view them as kind of a roadmap, but it's worth noting how much we talked about that doesn't meet the technical definition of lobbying, or there are specific ways that you can fund, for example, voter registration drives from a private foundation. There are paths to doing that. There are paths to funding organizations that you know will engage in lobbying activity through a private foundation. There are pretty clear limits for public charities that want to engage in substantial amounts of lobbying that they feel is directly related to their missions. The 501H election provides a clear path to do that without having to worry about whether you're crossing that threshold into more than an insubstantial amount. So I think the takeaway from this that we hope to impart is that there's a lot you can do as long as you're mindful of the specific things that you need to be aware of that you definitely can't do. So knowing the rules helps you stay within the limits of the law, but there's a lot that is available for both public charities and private foundations who want to do more work in this space. And that's an area where the council wants to be a resource for you, helping you understand what you can and can't do. Our government affairs team is great at helping you understand, now that you know what you can do, what are the best ways to actually go about implementing this. So we're always glad to help or to field your questions on these issues. And I see we had some chat questions. I know we don't have enough time to directly address all of these, so we're going to be fielding these questions and we'll follow up with whether they're submitted here or in the form. We're going to make sure we address all these questions that came in today in response to our presentation.
Thank you, Ben. Thank you, Ramy. Just one final announcement is that we have a training open for registration. It's the Essentials of Policy Advocacy for Grantmakers. It'll be on October 6th and 7th. It'll run in 2 afternoons Eastern time, and it's open for registration now. We'll be covering a number of things, but this specific training is part of a prep for that training. And so this is all connected, and we want to make sure that we are gathering all the resources for you. We've shared a number of resources in the chat, and we want to make sure that you get those in an organized way. So we'll be sending out a follow-up with the resources we shared today, in addition to the FAQ, the frequently asked questions that we're going to put together with the questions that you've submitted today and through the form. And with that, I wanted to wrap up. Thank you so much, Ben, Ramy. If you have any other questions for us, you can reach us at webinars@cof.org. And thank you for being with us today. Bye, everybody.